Welcome everyone to a brand new episode of our Immigration and Jobs Talk Show. I'm your host Rajni Bharara. And today we are delving into the world of family-based visas, exploring how they can unite loved ones and unlock opportunities for a brighter future. And who better to guide us through this complex terrain than our esteemed guest, Sonal Sharma, an experienced immigration attorney with a passion for reuniting families. So sit back, relax, and get ready to discover the possibilities of family based visas. And without any further ado, please join me in welcoming Sonal Sharma, everyone. Sonal, thank you so much for being here today.
Thank you.
I'm doing good. How are you?
Very well, very well. It's Friday, so it's good.
Yeah.
Week.
Uh-huh. And Fridays always it makes Fridays always makes everyone happy. So yeah.
Yeah, after a week, hard week, it's weekend time.
That's true. That's true. And Sonal, but I see a bit of a lag from your side. I don't know if my team can also see it and the viewers can also see it or not, but I see a little bit of lag from your end. Okay. Okay. So, yes, my team is also telling me that it is a little bit of lag, maybe some technical issue. If you can please check that.
Oh,
Um, you know but before we move ahead, let me read out this important disclaimer that is there on the screen. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. After this, everyone, I would like to tell you that we are live on LinkedIn, YouTube, Facebook, Twitter, and the handle is Immigration Talk Show. So don't forget to subscribe to us. And after that, I would also like to tell you that if you have any question related to family visas for Sonal, what you can do is you can comment with your questions and we'll be glad to answer. So, all right. So now, without any further ado, let's get started, Sonal. I hope the
sure.
problem is sorted now. Yeah, it looks a
I
little
think so.
yeah, it looks a little better. Thank you so much for fixing it. Okay, so Sonal, let's break it down in simple terms. We are discussing family visas today. So
Mhm.
imagine you have a family member who lives in a foreign country or maybe in another country, like
Mhm.
one's grandma or a cousin, right? So now to bring them live where you are,
Mhm.
you need to meet certain rules, right? So,
Mhm.
Sonal, if you could please tell us about the rules or what we call eligibility criteria for bringing your family members there.
Sure. So, what you can bring family members, but you cannot just bring everybody, right? You
Right.
cannot bring cousins. You cannot bring like third degree relatives and stuff. So there are
Okay.
different categories of relatives and family members that you can sponsor. The first one is immediate relative. It's called IR category, which is basically for US citizens to sponsor their spouses, their children, and their parents. So any US citizen who is 21 years of age can sponsor their spouse, their children, and their parents, and it is called immediate relative. This is considered the best category because there is no priority date set for this, and it's always current. So you could file anytime you want, and that's the fastest way of getting your immediate family members to United States. So there are other family members who fall under different categories, and that's called family-based preference category. Now there are four categories under the family preference category. First is F1, that's called first preference, which is for unmarried sons and daughters who are 21 years of age and older of US citizens.
Okay.
Second preference is F2A. These are for spouses and children. Children are unmarried and under 21 years of age of lawful permanent residents, means green card holders. Then second preference category F2B, which is for unmarried sons and daughters who are 21 years of age and older of green card holders. Third preference category is F3, which is for married sons and daughters of US citizens. And fourth preference category is F4, which is for brothers and sisters of United States citizens if the US citizen is 21 years of age and older. So these are different categories where you could qualify to immigrate to United States if you have the qualifying relative who will be sponsoring you either under the IR or one of the family preference categories.
Okay, all right. Thank you so much for explaining, such an important question here. Okay, but I think we already have discussed my second question as well, which I was about to ask you about if you can please explain different type of family-based visas available and their respective requirements.
Mhm.
So if we can go a little bit deep into explaining all these, family-based visas, because like you mentioned in the first question itself, that people, you cannot always bring your cousins or your other relatives, right? So people must
Yes.
also have this confusion. So if you can please clarify that as well. So why can't we do that? Why can't one do that?
Well, so you can only bring like your immediate relatives or under preference categories because that's considered your immediate family. You can certainly bring your cousins and everything, but there are other ways of doing it. Like if you have a business in the US and then you are trying to find somebody qualified to do a job, you can certainly sponsor your cousin on an employment based visa through your company. So you can bring your cousins and other relatives through other availability of visas and categories, but under the family based visas, these are the only relatives that you can bring under different categories of either immediate relative or family preference categories, because otherwise then the immigration is like a big issue. So reason for all these family based visas is family unification, right?
Okay.
The United States government wants families to be together. So the immediate family is your brothers, your sisters, your children, your spouse, and your parents. That's considered a big whole family where you
Right.
can bring the whole tree together. And that's what they want to do. They want to unite the whole family, and the theme is family unification. And that's why all these categories are available for different family members to immigrate to US.
Okay, okay. Thank you for explaining that. Thank you so much. But about, other members, let's say friends or someone else who one would like to, sponsor. So are there any other options or alternatives available for them to still sponsor their like family members, or, like third uh, a family member, or a third relative, like we say, second cousin, third cousin. So do we
So
have any options?
not under the family visas, right? The family visas are whatever the category is explained there.
Right,
But
right.
yes, you can get them through like work visas, like if there is an employment opportunity and you cannot find after testing the labor markets in the US, then that can be sponsored through work visas. But under the family visas, you can only sponsor your brothers and sisters, which is F4 category. I see a question in the chat which says, my uncle is a US citizen. He had sponsored his two sisters in 1998. How did that take place? Yes, because there is a category for it. F4 special category where you can sponsor your siblings, either brothers or sisters. It's just that it takes a long time for it to come through, but there is a specific category where you can sponsor your brothers and sisters, immediate brothers and sisters, or at least you have to have one parent in common. So step brother sister are also eligible, but one parent has to be common between the siblings for you to be able to sponsor. So those are the categories where you could, but for other categories, other relatives, you just have to figure out another way to bring them here if there is a possibility.
But is there? The question is that.
Not on the family based
No,
visas. I've
not
already
under family
explained
based,
the
but
family.
other.
Yeah, the other categories are there where you can explore the work employment, you can explore whether depending on where they were born, if they was, yes, they are your third relative, but what third relative was born in Australia? right? Then they have an E3 visa, which they can come here. It's a non-immigrant work visa. Then they can come here, get sponsored through work. So there can be other areas which can be explored, but it is too broad for us to just go into every possibility that could be there
Right.
for them. But they cannot come under the family-based immigration because there are set criteria,
Yeah.
set categories which can be used for immediate relatives of preference-based categories.
Absolutely. And because this episode is specifically dedicated to family based visas, so let's just focus on that. And Treasure Technologies has also posted something else. He says, yes, they did their process. Was started 10 years ago, and then by 1999 they had immigrated to the USA. Okay.
Yes, so it takes a longer time because there is a priority date for those categories. And, depending on which country you are coming from, it can take longer. So, for some categories, you will see Mexico has a very long wait because there are a lot of siblings, a lot of brothers and sisters who get sponsored, so they have a longer wait. But if you look at India, that's slightly better, but still a longer wait. So, like for example, for India, if you have filed under F4 category for your brothers and sisters, today people whose green card was filed in 2006 are getting their green cards now in 2023. So that's the time lag you're seeing. So it's a very longer process. So say somebody is 21 years of age, a US citizen, and wants to sponsor their siblings who are right now say 10 or 15 years old, then yes, they can do it. And by the time they get the green card, they will be adults in their 30s, well, but it's still okay, right? They can still come here and have a life here and get. But it's a longer time wait for preference categories. For immediate relatives, the wait is not that long because those are considered the immediate family, and then they are the preference. They are treated like they need to be adjudicated first because they are the immediate family members that should be together, like the children, the spouse, the parents. They should live together, and that's why there is no backlog for them.
Okay. All right. Thank you so much for answering the question. Triza, I hope you have got the answer for your question. If you have any more question, you're more than welcome to post them. So, all right. So he says, thank you for answering, attorney. Thank you
Sure.
to you too for asking the question. I hope you're happy. So now let's quickly move to our next question. So now next question is about the timeline. So if you can please talk about, how long does it typically take for a family-based visa application to be processed?
Okay, so there are different timelines for different categories, right?
Okay.
So for immediate relative, like I mentioned, those are the first preference. They are considered immediate relative. There is no backlog. Their priority date is always current, and they are adjudicated much faster than the preference-based categories. So if somebody is in US, in whatever visa status, or if they're physically in the US, and they qualify for an immediate relative visa. So suppose somebody is on work visa, H-1B or whatever visa, work visa, and then they get married to a US citizen. So now they are in the US and they got married to a US citizen, they qualify for an immediate relative petition. The process that's going to take them from filing, first of all, because they are in the US, they can do a one-step petition, which is file the I-130 and I-485 together in the US. That process currently, right now, taking, depending on the jurisdiction, from somewhere from 12 months to 18 months. At least the cases I'm filing and seeing, all marriage-based cases to US citizens are getting approved in about 12 to 18 months. So that's the timeline for somebody who is in the US through I-130 and I-485. Now, if you are not in the US and you still qualify for IR, say spouse-based petition, then it can take like a little longer, because the first step would be that you will file an I-130 with United USCIS, and then it gets approved. Then the case will be transferred to National Visa Center, which is NVC, which will ask for further documentation that needs to be completed. Once that's completed, then they move the case to Department of State, which is consulate. And once the consulate is ready, they will schedule an interview for you to come take the interview, and then you get the green card through interview, which means they give you a visa in your passport, which you use to enter the US as a green card holder. So now there is a little bit more time time is consumed when you go through consular processing and the person is waiting outside, because now there are two additional steps that have to be taken by NVC and consulate. Now, why it generally takes longer? Because consulates, like in COVID, right, everything had shut down, so no visas were
Mm,
adjudicated through consulate. So those things can happen and it generally takes a little longer, and in those cases you're looking at about 2 to 3 years timeline. But if you're in the US, you're looking at about 12 to 18 months. Now that is for immediate relatives, right?
mm,
Parents, children, spouses of US citizen. Now, if you
mhm,
go to the preference categories, there is priority date set for that. So
mhm.
you can file the I-130, and then you will have to wait for the dates to become current. Just like for an employment-based one, you have I-140, but you wait for your priority date to become current
Right.
before you can either file an I-485 or get the consular processing done through consulate. It's the same with preference categories. Depending on when your priority date becomes current, you will be able to take the next step. Now,
Mhm.
like we spoke about F4 categories for brothers and sisters, right? The I-130 itself is going to take very long time. It take years sometimes, because
Mm,
USCIS knows that they are not going to, like, your dates are not going to be current for next 15 years. So there is no
mm.
rush for them to
Yeah.
adjudicate it and process it and everything. So depending on the type of case and where you are physically located, the timeline can be different, but the earliest you can get if you are in the US, it's 12 to 18 months under the immediate relative category.
Okay. Okay, all right. Thank you so much for answering the question, Sonal, and in so much detail. Also, you basically clarified all the steps and everything. So let's quickly move on to, because we also are getting a lot of chat questions from our viewers. So we are definitely going to take them, but before we move into them, we also have to complete our own set of questions, right? So, if you can also please talk about if there are any limitations on the number of family based visas that can be issued each year.
So yes, there is number. So under family-based category for IR category, immediate relative category, there are 254,000 visas allocated each year. But there is, if the number surpasses that, there is no limit because it's immediate relative. They
Mm,
don't create any backlog. There is no priority date. So even if, like, in a given fiscal year, the number goes above, that's fine. But every year the allocated number is $254,000 and for 54,000 visas. And then for preference based, family preference based category, the number of visas allocated are 226,000. And that does not surpass because there's a priority date. So that's why
right.
there is a backlog and that's why there is a cutoff date. So the number of visas on between IR and family preference is about over 500,000 visas each year, but there is no limit for IR category. It can be more than the allocated number as well.
Okay, great. Thank you so much for answering the question, Sonal. Now, let's talk about the documentation also, right? Because, of course, if you file, so you have to go through a documentation steps, right? So, if you can please also talk about what documentation is required for a successful family based visa application.
Sure. So it will again depend on the type of petition and who is applying. So
Mm-hmm,
if you're applying for your spouse,
mm-hmm,
then it's based on marriage. Then you have to show, first of all, there is a marriage, that you guys got married, right?
mm-hmm,
It could
mm-hmm,
be in US, it could be out wherever it is. You have to show there is a marriage that has taken place between the person who is filing the petition, which is petitioner, and the person for whom the petition is being filed, which is this beneficiary. So the first document for a marriage-based case would be marriage certificate. And then there is a requirement that the marriage has to be consummated. So, which means that right now, there are proxy weddings, you can get married over internet and all that.
mm-hmm,
But for you to be able to sponsor somebody at some point, you will have to show that the marriage was consummated, that you guys were together at some place at some time. It doesn't have to be US, it can be outside, wherever, but
mm-hmm.
physically you were together to have the marriage consummated. And then the third is basically bona fides of the marriage. So if the marriage is less than 2 years old, so say you got married today, you can file it tomorrow, right? Because now you're married. In If the marriage is less than 2 years old, then you have to show bona fides of the marriage, which basically means that you have to show that this marriage is not just for immigration benefit. This is a legit marriage. And now, what are the documentations you can show to show that this is a legit marriage? Is like you guys are living together, you have a lease together, or you bought a house together. If you have like bank account together, which shows that you are commingling your finances like any couple does. So now, as modern couples, they don't commingle all of their financial assets, right? They have their separate bank accounts. That's fine too. But like if you're living together and you're contributing towards expenses, then you might want to show at least one bank account where you both put your operating expenses and you use that to run your household. Now you can show that one of the spouse, either the beneficiary or the petitioner, if the beneficiary is in the US, is on the health insurance of the other person as a spouse. So that shows that you're listed as a spouse for health insurance. You can show life insurance policies where the other person is listed as a beneficiary. So there are a number of documents that can be shown to show that this is a real marriage. You're living like a married couple, and this is not just for immigration benefits. And USCIS does check it. They do site visits as well. So if you have given them an address that this is where we live together, they can come and check it out whether you're living together or not. They go ask the neighbors, like, do you know this couple? Like, do they live here? Have you seen them? So in addition, you also might want to attach photographs of marriage, photographs of you as a couple with both families, the petitioner's families, the beneficiaries' families, friends. If you have attended, like, as a couple, you have attended your friend's marriage, you might want to get letters from your friends and family who can attest to your relationship. So, depending on what the situation is, there is a lot of evidence that you will have to show that this is a real marriage and not just for immigration benefit. Now, if we move to different kind of IR case, which is for parents, right? If you want to immigrate your parents to US, then you will show, first of all, the birth certificate showing that these are your parents, right?
Right.
That's the most important document to establish that biological relationship or the relationship through adoption or whatever. You will have to show some document which clarifies that they are your parents, which allows you to sponsor them. So that's the most important document in terms of relationship with parents. It's less than what a marriage-based document petition would look like, because that's like you're qualifying somebody on the marriage. But for parents, if you show that yes, there is a relationship, you were lived. So if you were born somewhere outside, and you still have attained US citizenship, either yourself through marriage or work or whatever, green card and then naturalization, you can still sponsor your parents, right? So you will show the relationship with the parents. So depending on who you are sponsoring, you will have to show first and foremost the relationship documents, how it is established, and it is indeed the relationship that you're claiming it to be. And then based on the petition, you will add additional documentation depending on the circumstances and the relationship.
Okay, understood, understood, got it. But Sonal, still, I would like to know from you that are there any documents, specific documents that people tend to forget about or overlook, which they should be very, very careful about if they have to get, if they want a successful visa, uh, you know,
Sure.
application.
So, you know, the most important documents in family-based immigrations are your birth certificates,
Okay.
because that those are really important. So if you're born in US, it's pretty straightforward, right? You have a birth certificate, but you could be born outside of US as well, but still a US citizen. And like sometimes you don't have like say if you were born in India, say before 1970, you might not have a birth certificate because at
Right.
that point there was no requirement to have the birth registered. So it's very important that you have the documents just showing your birth certificate or birth date or whatever, especially if it is required based on the petition, that you get. If not the birth certificate, then documentation, alternative documentation that USCIS has posted or Department of State has provided under reciprocity schedule, that what kind of documents can be used if you don't have a particular kind of document. So before you even start, there is a, if you go to USCIS website, like for your own education, right? If you type I-130, it lists and it tells you initial checklist. That basically lists out like what type of documents you should have even if you're thinking about applying for a family member. But yes, the marriage certificates, the birth certificate, the passports, relationship documents are the most important documents because it is family based and you need to show that you're family.
Yeah, of course, of course. All right. Thank you so much for answering the question, Sonal. And now let's move to our next question. Even though you have, already answered this question somewhat, but still I would like to take it. So if you can also please talk about how does the immigration process differ from for immediate relatives versus preference category relatives?
Yes. So the documentation in like petition is the same. You file an I-130, whether you are sponsoring immediate relative or you're sponsoring preference category relatives. There are additional forms. If it is a spouse, then there is an I-130A as well in addition to I-130. That is not there for any other kind of, like if you're sponsoring your children, parents, or family preference category, then you don't file that. But so the first step is I-130, which is similar in all the cases. And then the next step would be if the person is in the US, then you will file an I-485, either after the I-130 is approved or together, depending on the circumstances. And if it is family-based case, then and the person is not in the US. So if you are in the US and you qualify for a family-based preference category, you can be sponsored, but you will have to maintain your status until you're able to file the I-485. And you can only file an I-485 when your priority date is current under preference category for relatives. So during that time, while you are here waiting for your priority date to become current, you will have to make sure that you maintain your status. So you could be here on an H-1B, right? But you got married to a green card holder. Now
Right.
the green card holder can sponsor you, and because your dates are not current, he can file an I-130 for you, and you will have to remain on your H-1B until you file the I-485. Once you file the I-485, then you can stay here. You do not necessarily have to maintain your H-1B, but you will. But that is different in case of immediate relative cases. That's the difference,
Okay.
main difference. So if you are, so suppose somebody entered here uh, on a B2, and they were here for 6 months, they met somebody, they liked them, they fell in love, they got married, but or like 6 months have passed for B2 and this person did not go back, did not
Okay.
file for extension, did not change any status, and now is in the US illegally. But
Right.
then they got married to a US citizen.
Mm-hmm.
Now, as long as you have entered United States legally, if you are marrying a US citizen or if you are qualifying for like immediate relative as an immediate relative petition, then it does not matter whether you are in status or not when you're filing the petition. So as long as you entered US legally. So if your entry in the US is legal, then if you're an immediate relative, you have a lot of flexibilities that is given by the government because again, the purpose is family reunification and they want the families to be together. So if you are an immediate relative, that all these hindrance of maintaining status or working without work authorization, those does not create problem, but those will be problem if you are in preference based category. You cannot have unauthorized work, you cannot be out of status, all of those things, because if those are there, then you have to first cure those before you can get the green card. And there are ways of curing it, but those are the main different ways. The processes are different, but in terms of filing the petitions are similar, but the pathways might be different depending on different circumstances.
Okay, okay. But are there any, I would say, circumstances where a family member may be ineligible for a family-based visa?
So there could be, and that could be for immediate relatives also, right? It's not that they are just eligible, whatever the case is. So there are inadmissibility grounds on which anybody can be denied, right? So those are health related, like if you have a communicable disease, HIV or other, TB. There are a bunch of. If you have that, then you could be denied. There are public charge grounds, which means that if your condition is that the day you enter as a green card holder, you will become a burden on the state. You will start taking basically taxpayers money to support yourself. That's
Yeah.
if they think that's going to happen because they want you to support yourself, or the petitioner who is sponsoring you has to file an I-864 showing financial support for you. There are national security reasons, which is very broad. Like it could be anything. It could be your past experience in military, or you were a part of terrorist organization. It could be anything.
Yeah.
So national security reasons are there. Public charge is there. Health is there. Criminal convictions. If you have felony charges in US or other countries where you're from, then that could be a reason that you could be denied. There are, if you were here, if you entered US illegally and then you have unlawful presence, that could be a reason. If you entered US illegally earlier and then you were put in deportation and you did not attend those hearings, so there is a whole gamut of reasons that could be a reason that you could be inadmissible. But depending on the situation, there are solutions to that as well. And if there is a solution for that, you could go and apply for it. And if it is approved, then you will move to the next step to get the green card.
All right. Okay. Got it. Thank you so much for answering the question, Sonal. We are 32 minutes into the show. But before we again continue our discussion, we would like to go for a short break. But everyone, don't go anywhere because when we return, we'll dive deeper into the process of obtaining a family based visa and explore some common challenges faced by applicants. And we are, of course, going to take up your questions next. So stay tuned, don't go anywhere, and enjoy the break.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 732-707-9151 or mail us at rajni@higheritpeople.com or visit our website www.higheritpeople.com.
Welcome back, everyone. I hope you enjoyed the break. We are here with attorney Sonal Sharma discussing family based visas and how they can transform lives. So, before we move ahead now, I would like to quickly read out this important disclaimer, which is here on the screen. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, now, Sonal, welcome back. Now, let's give my question a rest and let's move to the chat questions from the viewers. So, a first question that I would like to take is of Ravindra. So Ravindra has actually posted a couple of questions here. So let's just address all of his questions. So the first question that Ravindra wants to know is, I am a US citizen and my spouse is currently living abroad. We have been married for over 10 years, but we have been separated due to circumstances beyond our control. I have filed a form I-130 to sponsor my spouse for a green card, but the processing time has been extremely long. Meanwhile, my spouse's home country is experiencing political unrest and their safety is at risk. What are our options for expedited processing or emergency visas, and how can we demonstrate exceptional circumstances to USCIS?
Well, it depends why it is taking, because if it is a U.S. citizen who has sponsored, then it's immediate relative, right? Whether you are separated or not, that's not, as long as you're married, you still qualifies for green card. So what stage the I-130 is, why it is taking longer, if it is taking longer, then you will have to figure that out at the first stage with the USCIS, like what's going on, why it is hold up, why it is taking longer, and if you need to get that expedited. So there are different stages of this kind of petition when the person is outside of US, right? One is I-130, which is filed with USCIS. Now, if it's taking way longer, then you might want to reach out to USCIS, expediting it, giving the reasons, like in this case, that there is unrest in the country and you want to unite the family together quickly, then that could be a reason. But you also could take congressional help. You could reach out to your congressional representative and ask them to make an expedite request to the USCIS on your behalf, and that in most of the cases generally works if there are genuine reasons. Now that's when if it is I-130 stage. Now if the person is outside, like I mentioned, that after the I-130 is approved, the case moves to NVC, and once you've uploaded all the documents that are required and it's documentally qualified, move it to Department of State and to the consulate. Now depending on which consulate going to, now this question is basically that there are political unrest, and if that is there a US consulate in that country anymore, right? Say if it's Russia, like there is no there anymore, then you figure out where this person is going to go to get the interview and visa. So all those things are, and if it is a country where there's unrest and US consulate is there working and open, then again, depending on where the case is stuck, you might want to reach out to the congressional help and getting it moved along on the why it is being stuck. Now if it was stuck like during COVID, that nothing was processed because the consulates were shut down, then if there is a backlog, nothing is being done, I don't think any expedite thing would help, and neither it helped at that time. But in most of the cases, depending on where in the process the petition is stuck, you might have options to reach out to the appropriate agency to move it along. Or if there is a document because of which that is pending, then you need to understand what the reason is, first of all, why it is, and then take the appropriate action, which could reach from, if it is USCIS calling, applying for expedite, if it is not working, taking congressional help, and if it is like stuck at the Department of State level where it is documentary qualified for, say, 2 years now and you have not had an interview, then you might want to look at mandamus case, which is filing in United States, saying, basically asking United States government to do their job and pick it up. Now that case does not mean that you will get a positive result. It just means that it will push the government to give you an answer because there is an unreasonable delay. So depending on where the case is stuck and what the situation is, there might be different ways of with it, litigation being one of them, or congressional help being another. So depending on the to, I think, work with your attorney to figure out what is the best way to move this along.
Okay, all right. Or Ravindra, what you can do is you can directly, connect with Sonal, and you can connect with her, and she can help you with your problem in a better way. And if you want to connect with her, you can connect with her on her phone number, which is +1 646 360 5955. I repeat the number, +1 646 360 5955. Her email is sonal@sharmalawAssociates.com, and also her website is also mentioned here, which is www.sharmalawAssociates.com. You can also visit that. Yes, and she'll be glad to help you. Well, after Ravindra, I would like to take Raj's question. So, Raj wants to know, are there any specific documents or evidence required to support a family based visa application? How long the process usually take from application to approval for a family based visa? I think we already have discussed this question, right?
Yes.
So,
Yeah.
Raj, I would request you to please, after this session gets over, please do rewatch the whole episode, and you'll be getting the answer for your question. But thank you so much for posting it, though. Now, Tarun is here, and Tarun wants to know something. And he says, can you explain the eligibility requirements for sponsoring a family member for immigration? What are some common challenges or obstacles people face when applying for a family based visa? What do you have to say, Sonal?
So, yeah, eligibility requirements we already discussed, right? Depending on what category
Right.
the person is falling in, you have to see, first of all, is that a relationship or family member that can be sponsored in one of the categories that's available? So, spouse can be sponsored, children can be sponsored, parents can be sponsored. Um, Children who are over 21 can be sponsored, brothers and sisters can be sponsored. So there is a whole, you'll have to figure out first of all which category they fall into and whether you can sponsor them or not. Second, whether they are here in the US or they are outside the country. Depending on the category, it would make sense whether they are here and then file or they are outside and then file. Like say for an F3, F4 category, which is taking 15 years to get green card, there is no way they can come here and just stay here for 15 years without any visa. So that's not a possibility, right? So they will have to figure out, stay there, the process will go on. Whenever it is current, they get the green card, they come in. For categories where there is a possibility of somebody coming here and staying here, then sure, they should take that. The process is much faster when you are in the United States, and you might be able to file the I-130 and I-485 together, and that way would help you staying here, working, and all those limitations that might come waiting outside will not be there. So that's one. The challenge, common and obstacle people face is that when they're stuck outside, right? It can take a whole reunification or unification family. So if there is a way that a person can legally be present in the US or they are already present, then it is special for them to be physically here to file the case. In terms of challenges, there is also another, like we discussed, like documentation, right? You need to have a documentation. You're
Yeah.
asking for an immigration benefit. An immigration benefit is not your right, it's a privilege. It's at the discretion of the government, and you have to convince them that you are eligible for that immigration benefit, and you can show that through documentation. So it's very important that you have the correct documentation, up to date documentation, and specific documentation that is required for a specific case. So like I mentioned, like if you're filing for your parents, the most important thing for you is birth certificate, right? If you do not have the birth certificate, and it can take months to get the proper format certificate or the alternative documents from outside governments outside United States. Like in India, you have to go to a particular municipal corporation where you were born to get that document. Now if that is not registered, then you will have to get an unavailability document, and then in addition additional affidavits towards your birth. So you might want to start ahead and get your documentation, so that once the process is started, you don't want to get it stalled because a document is missing. So that's the biggest thing that you need to understand. Distance and documentation, those are the things that you need to plan ahead to figure out what's the way forward and the easiest and the fastest way to get the green card for your family members.
Okay. All right. So, Tarun, I hope you're happy and I hope you have got the answer for your question. Thank you so much for posting it. And please let us know where you're watching this live session from. All right. So, after Tarun, let's move to Zaki. And Zaki has asked a question which I think, half of it we already have taken and you already have answered, but we would like to take the second part. So, let's read out the whole question first. What are the different types of family based visas available for immigration to the USA? And can you provide examples of successful cases you have handled involving family based visas? First part we already have taken, but talking about the second part, if you can please talk about, Sonal, a case where you have taken, you must have taken, a family based visa and where you were involved in handling that case.
So yeah, well, I've handled all preference category cases, right? There are I have handled cases for spouses, I've handled cases for parents, I've handled cases for brothers and sisters, I've handled cases for children one for permanent residents. I've handled cases for spouses of permanent residents, whether they are here, they are outside. I have done both. I've done adjustment of status. I have done cases for consular processing. So all type
I
of
think it's going
cases
to
we
take more than
see.
24 hours if we
Yeah.
get into.
So I've done basically in the end, I've done a lot of cases in all of categories and with different ways of doing it, I-485 or consular processing.
Maybe we can have another episode on the case studies, right? And where you can discuss the cases. I think that can be an interesting episode. So we can do this maybe some other time. But for today, Dia Banerjee is here. Dia um, wants, she has posted three questions actually. So let's quickly take them. So hi Dia, let us know where you are watching this live session from. And she says, I'm permanent resident and have filed a form I-130 for my adult child who is currently living in a country with a long wait time for family-based visas. However, my child has severe medical condition that requires ongoing treatment and care. If we wait for the visa to be processed, their condition may deteriorate. Deteriorate. I'm really sorry if I'm not pronouncing it correctly, significantly. And can we apply for, let me show it here on the screen. Can we apply humanitarian parole or expedited processing based on their medical needs? If so, what documentation and evidence would we need to provide to support our case? What do you have to say, Sonal?
So yes, in these conditions, they're not just going to give you the green card faster. That they will have to give it to you when the priority date is current. That's changed. But yes, you might have an option of applying for a humanitarian parole, which will allow you to bring your child here. For the medication or medical treatment that they need, or if like they're dependent on you for their day-to-day needs. So yes, humanitarian parole might be an option while the case is pending. They could still come here for all the needs that they have. So that is possible. So basically, in this case, you will have to show what the medical urgency is, medical help, what the problem is, if medical condition, the medical records, and basically the treatment options. So if the treatment option is available in the country where they are, then it's going to become a little difficult for you, right? Why can't you just go there and help or get the treatment there? So if the treatment is like, there are certain medical conditions where the treatment available only here, or it's much advanced here, which can help your child. So you might want to get that proof and evidence to show how it's going to help your child to get the treatment here. If it is only available in the US, that documentary proof from your doctor, or if they are going to get into an experimental trial or something, proof of that. So all of that you will have to show for them to be able to give you an humanitarian parole, for you to be able to bring your child here and give the treatment and care that the child needs while they are waiting for their green card to be processed. And they
Okay.
have done it. USCIS has done in the past for medical conditions where the family member needs that kind of help. They have given humanitarian paroles in the past for the person to come here and get the medical attention and need and care that they need with the family member while living in the US.
All right. Okay. All right. So, Dia, I hope you have got the answer for your question. Let us know if you have any more question or anything else that you'd like to know the answer of. So, you're more than welcome to post it. So, also, please let us know if this answer helps you, if you're satisfied, and yes, if you have any more question that you would like to know, please let us know. Zayed is also here. He says, what are different types of family based visas available? Okay, I think we already have taken this. Really
Yeah.
sorry for taking it again. But okay, Hashura's question I don't think I have taken. So Hashura says, how does the immigration process differ for spouses, children, and other family members at the same time? Are there any limitations or restrictions on who can be sponsored? I think we already have taken this, right?
Yeah.
Yeah. So let's take Rahul's question. So Rahul says, um, how does the process differ for adopting a child from another country versus sponsoring a biological family member?
So, what in terms of once you have adopted the child, the applying system and the process is the same. I-130 or 85, whatever, or consular processing, whatever. But before that, before you are eligible to apply for an adopted child, there are certain requirements that you have to meet depending on how the adoption is happening and where the adoption is happening. It's a whole different topic. I won't be able to get into like the details of what adoption is the right adoption, like
Yeah.
proper adoption for immigration purposes. But once you have done the adoption properly and have met the requirements, the process remains the same because now you have established that this is your child. Whether it is biological child or whether it is adopted child, it will not make a difference of the process because you have established the relationship. But yes, before that, there is, whether depending on whether the adoption is under Hague Convention or it is not under Hague Convention, which country it is being adopted from. And then generally there is a 2-year residency requirement that once you have adopted a child, the child has to live with you physically. That's also there. Now that challenging, right? If you are here and the child is, you bringing child from somewhere else, then
Yeah.
how do you show that? All of those, but that's another separate process altogether, which you have to meet first before you will be able to apply for the child. But once you've established it and all the parameters are met, that it is done, adoption is done the way is required by the law, then you will be able to just sponsor it like you would sponsor your biological child.
Okay. All right. Okay. Thank you so much for answering the question, Rahul. I hope you're happy, but he also has one more question. So, what he wants to know is, are there any specific consideration or requirements for elderly family members seeking immigration through family-based visas?
Well, it depends on, what the situation is, but they would want to see that, what elderly mean. Elderly could be 70 years of age, elderly could be 90, 95 also, right? But depending on the particular situation and their health and their issues, be some concessions in terms of like, normally when you go for visa, you only the immigrant who is beneficiary, who is going to be immigrating, is allowed to go to the interview, right? But in some cases where there are elderly family members who need help or whatever, they might allow the petitioner also to come the interview so they can support. So all of those are there, but in terms of like, is the process different, is the documentation different? Not necessarily. There is no such thing. You still have to prove the relationship, you still have to show all the documentation that is required. But yes, in terms of logistics, there might be some considerations depending on the situation that each agency might be willing to give if it is required.
Okay. Okay. All right. So Rahul, thank you so much for both your questions, and I hope you have got the answer. If you're happy and satisfied, let us know. Also, let us know where you're watching this session from. Thank you so much for tuning in, and don't forget to subscribe to Immigration and Jobs Talk Show. And Zayed is actually back. So Zayed, maybe he thought that we didn't take his previous question, and we just asked him to rewatch the whole episode after the live gets over. So he's back with another question. So he says, I'm a US citizen and my spouse is a recipient of Deferred Action for Childhood Arrivals, DACA program. We have been married for several years and have two US born children together. Okay. And there's a second part. And however, my spouse recently traveled abroad for a family emergency and was detained by immigration authorities upon return. Citing a prior order of removal from over a decade ago, we have since learned. Can we have the next part as well, Zayed, if you can please? Okay, maybe he's typing it right now. So let's take. Okay, so he's back. He says, we have since learned that the prior order was issued in absentia and my spouse was never notified. What legal options do we have to challenge the prior order, and how can we fight to prevent my spouse's deportation? And maybe there's one more part to it, but till now, would you like to take it, Sonal?
So, this whole situation is very tricky and this is very case specific. And I'm not going to discuss a legal strategy here because it's a very case specific. They need to go to an immigration attorney to understand what their options are. But generally, DACA is not a status, it's not a lawful status for you to be able to. Adjust status. So DACA people are who came here as a children and then never left, and then at some point under Obama administration they were given a status which is called the DACA deferred childhood status that they were given. Now they can stay here. Now they have status which gives them work authorization, but they cannot travel and come back in because once you leave, this whole process of like unlawful presence and you have been in the United States for a very long time, all that comes into picture. Now the problem is whoever advised them, I don't know if they took advice before traveling and going out of country, because once you're on DACA you can't just leave and come back. That's not how it works. You might, now depending on what the circumstances were, right, like they might be eligible for some relief, but given that this deportation and absentia and whatever, they need to go to a lawyer who will be able to pull up their record from whatever earlier proceedings were to see what was done and what was not done for them to be able to fight this deportation. I don't do deportation cases, so I won't be able to give them like an advice here, but they should reach out to a lawyer who would be able to either a FOIA, under Freedom of Information Act, get all the documents from the prior proceedings and then review them and see what the options might be for this person to be able to, get the status they are looking for.
Okay, all right. Thank you so much, Zayed. I hope you have got the answer for your question. I mean, Sonal did try a little bit to, give you the answer. But as she said, you don't do deputation, is what you said,
No, I
right?
don't.
Yeah.
Yes, I don't.
So yes, you will have to go to an immigration attorney who can help you with this. And if you want to, everyone, if you want to reach out to Sonal, what you can do is you can reach out to her. Her number is +1 646 360 5955. Her email is sonal@sharmalawAssociates.com, and also you can visit her website, which is www.sharmalawAssociates.com. Yes, the information is presented on the screen, so you can note it down for yourself. And if you're looking for a project placement or visa sponsorship, please you can give me a call at +1 732 707 9151. My email is rajni@higheritpeople.com, and you can also visit our website, which is www.higheritpeople.com. Remember, we also sponsor H1B visas and other work visas based on job availability and regulations. And To everyone else who's watching us, if you're watching this live episode after the live has ended, you can continue to post your questions. My team will help you with an answer. So it's 11 o'clock, Sonal. So I think, unfortunately, that's all the time we have for all the questions today, but we still have a lot of questions pending. So would you like to do a second episode of this topic and cover the pending questions in the next episode?
Sure, we can figure something out.
Yeah, because we also have, we wanted to also, I actually wanted to talk about the financial responsibilities and, more about family based visas. So maybe we can cover
Sure,
in the next week episode.
sure,
So
sounds good.
great. And thank you so much again for joining today's session. Thank you so much, Sonal. I know you must be really busy, but thank you for taking out time on a Friday and doing the show. Means a lot.
Sure, thank you for having me. Have a great weekend.
You too. And to all of you, let's meet soon. But until then, remember, love knows no borders. So keep watching and keep subscribing to Immigration and Jobs Talk Show. And until we meet next, don't forget to subscribe to Immigration and Jobs Talk Show. I'm your host, Rajni Bharara, signing off. Bye.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 732-707-9151 or mail us at rajni@higheritpeople.com or visit our website www.higheritpeople.com.